Hello, everyone. Today's episode is on bringing on new shareholders. This video is not legal advice. We recommend you retain a lawyer and receive legal advice for any questions you may have.
You had an idea for a business. You didn't just leave it at an idea. You acted on it and started a business. You decided early on that you'd operate your business through a corporation. You worked hard. Long days, long nights, weekends, holidays, and your business grew. You hired employees to work for you, and you provided value-added goods and services to your customers. But you need more help. You need help with steering the business. You need help with decision-making, with implementing your business plan, and you need help with adding a new business segment. You're also thinking about succession planning. And now you're thinking about selling shares in your corporation and bringing on a co-owner. How can you bring on a co-owner? How does another person acquire shares in your corporation? What rights would a new co-owner have? How can we manage the corporation with more than one owner? Let's consider some of these questions and more. So how do you make another person a shareholder? Two options. They can either buy shares from you, or they can buy new shares from the corporation. Any lawyer should be able to properly carry this out. But before you choose one, you should receive advice from your accountant about the best option to choose. There will be different tax matters to take into account concerning the purchase of the shares from either you or the corporation. And there should be some consideration about how the shares may be sold in the future. When all of that is considered, the method can be chosen. Now, you co-own your corporation with another. Essentially, the corporation has two shareholders. What does it mean legally that this new shareholder has joined? So what? We have a new shareholder. Bringing on a new shareholder means that the new shareholder has all of the legal rights that shareholders are entitled to. Generally, those legal rights typically include the right to vote for the directors of the corporation, the right to receive a copy of the financial statements of the corporation, the right to have an auditor appointed for the corporation, the right to approve certain fundamental changes to the corporation, like issuing new shares or selling all the assets of the corporation, the right to attend meetings of the shareholders and to vote, the right to make shareholder proposals, and the right to remedy in the case the shareholder is affected by the corporation's or any director's oppressive or prejudicial conduct. It's easier to imagine a situation where the new shareholder owns the same number of shares as you, the original shareholder. In that case, subject to a fair buy-in by the new shareholder, you may be entirely satisfied with establishing the entire corporation on a 50-50 basis, where all decisions are made on unanimous consent. However, you could also find yourself in the situation where the new shareholder will only end up with a small fraction of the shares you have, for example, 5 or 10%. In that case, it would seem unfair if that new minority shareholder had the same authority and power in respect of the corporation that a person with 90% of the shares would have. Now, the general corporate law commonly addresses this imbalance. This is true of small corporations and large publicly listed corporations. It's not a democracy. If one party controls the vast majority of the votes, they can generally direct the corporation in any way they want. Usually, a majority of the votes is considered 50+1, and a supermajority is considered 2/3 or 67%. There is another way the shareholders can bring even more certainty concerning their rights and relationship. The shareholders can negotiate and enter into a shareholders agreement with one another. A shareholders agreement is a contract signed by the shareholders that sets out how the shareholders will exercise the rights attached to their shares. It may restrict the powers of the directors to manage the corporation, and it may set out what happens to the shares owned by the shareholders upon the occurrence of certain events, such as the disability of a shareholder. How do you manage shareholder rights with your co-shareholders? Is your shareholders agreement up to date? What are your succession plans for the shares you own in your corporation? If you don't have a co-shareholder yet, is bringing on a new shareholder the right thing to do? That's all for today. Until next time.